Hear ye, hear ye, hear ye. All persons having business before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 775, People v. Adams. Mr. King, can you hear us?
I can, Your Honor.
And we can hear you very well, so please proceed.
Good morning. May it please the court, Brad for Stephen Adams. In a series of cases, many of them mine, this court has held that a plea of guilty can forfeit review of a challenge to the certificate of compliance. I am once again asking the court to review this using three possible methods. First, CPL 3030 sub 5, which we maintain places a duty on the trial court to inquire as to actual readiness. The trial court did not do that here. Second, the interests of justice. This court's intervention is needed to ensure statutory compliant communication between law enforcement and the people in Livingston County. And then third would be ineffective assistive counsel, which is our, I believe, point 3. For failure to make a formal 3030 motion that would survive a guilty plea.
Mr. Keem?
Yes.
Good morning.
Good morning.
It's not in either side's brief, so it makes me suspect that I'm reading the law correctly, but it looks to me like in this situation with the murder charge, that 3030 doesn't even apply.
So
for this particular charge.
Yes, so 245 would still apply, and it's possible that there could be a plea to some other charge, but 245 would still apply. That means due process, that means discovery for the ability to know whether to take this to trial or to plead guilty. In particular, in this case, in Livingston County has had this issue, is the boilerplate language that the DA's office has a standing request for police disciplinary records, but has no part in reviewing these disciplinary records. They are not co-equals. They're completely reliant on the sheriff's department to provide them with disciplinary records, and that is wrong. And that is not giving a defendant the ability to determine whether he or she should plead guilty or take a matter to trial. And that's what 245 was supposed to prevent. And
but that motion, as you acknowledge in your brief, Mr. Keem, and you've already reached the core of your argument, asking us to reach in the interest of justice, is I understood your brief and your argument today, the three options you articulate. I think one might be off the table for the ineffectiveness, given the fact that 3030 would be without merit, I think. Then you argue that we have recent precedent that says that you're wrong in terms of the forfeiture. And so then you ask us to get to it the interest of justice and perhaps pseudo deem the motion to be won under 3030, even though that technically wasn't correct. That's how I understand your argument. If I don't have it correct, please let me know.
No, Your Honor, that is my argument, because I do believe that this is wrong. And it seems kind of silly, the ineffective assistance of counsel argument, that you would submit a non-meritorious motion in order to preserve it, because otherwise you couldn't reach it upon a guilty plea. That just seems wrong to me. And this is also, it seems contrary to 245, which is why we'd ask the court to exercise this interest of justice jurisdiction to prevent this sort of really shirking the responsibility of the people and law enforcement to act as co-equals when reviewing disciplinary history.
Anything further, counsel?
No, Your Honor, unless there are questions about our other arguments in the brief.
Thank you, counsel.
Good morning. May it please the court, Josh Tonner on behalf of the people. Judge Curran, I agree with you in all respects that This case, because it is not properly preserved, because it's forfeited by the defendant's guilty plea, is not properly before the court. And the case may come where it is, but it isn't in this case. As to whether or not 3030, the speedy trial limitation would apply, based on whether or not it's a homicide case, it's correct. It wasn't addressed in either brief. We did address that, assuming that it would apply, that approximately 66 days of the 6 months had even elapsed by the time the defendant entered his guilty plea. I think that, I agree Brad has addressed this issue in brief before from Livingston County, and day may come when we have that argument. It is not this case. It is not properly before this court.
Any further, counsel?
No, thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Case 776, People versus Davis.
Good morning, Your Honors. May it please the court, counsel. Michael Whitmer for Demetrius Davis. Mr. Davis pled guilty to a rape in the first degree, received 7 plus 7 of a dock sentence. This case was...
Mr. Whitmer, pardon me for my early interruption, but just so you can address the issue that's on my mind, at least for the first one. I don't see in your brief where you raised or contested the waiver of appeal. And I wonder if that amounts, from our perspective, to a concession that the waiver is valid. So you didn't really argue it. I'm not being critical. Please don't misunderstand me. Being a lawyer is not the easiest thing in the world. I get that. But should we conclude that it's essentially conceded here that the waiver is valid?
Very specifically in relation to the voluntariness of his plea, I would definitely say that his waiver was not valid. But also, I don't think that he could have properly waived any of his rights. That's kind of the thrust of the appeal itself, is that this is a defendant that didn't know everything that was going on in the proceeding at the time when he took his plea, which came along with the waiver. At the time that the plea was taken, this is at the very outset of CPL 245, where this is January of 2020, right when certificates of compliances were first being filed, and there was an order issued to provide records in relation to this other CR number. It was very specifically demanded by the defense. It was ordered by the court to be turned over. The prosecution agreed to turn it over, subsequently refused to turn it over. A judicial subpoena was issued on the eve of trial. The records were gathered. The court, at the time, issued an order to the defense and to the prosecution, do not disclose the material that's involved. It's for counsel's eyes only. And so the defendant at the time did not know the basis of this information. The basis of the information was not inconsequential, based upon the fact that it is the defense's position that it's a rape case. It was not only CPL 245.20 material, but it was Brady material. It included information that the victim in that case came to RGH, to the hospital, on 30 prior occasions within the last 2 years, making similar allegations of rape. That information still, at the time of the plea, was not known to the defendant.
But it was known to his lawyer, wasn't it?
It was. I was ordered not to tell him, and from my perspective, I didn't like that. But at the same time, too, I knew that I couldn't tell him.
But you could still do your job and use the information on his behalf, couldn't you?
I could. It was my belief that it's the defendant's right to be able to decide whether or not to engage in a plea. And in this particular case, it wasn't from any fault of the defendant's. The defendant was struggling through that plea colloquy. He very specifically was asked about elements of the offense, denied them throughout the plea. Specifically asked if he had displayed a knife during this alleged knife point rape. He said, no, I didn't. The court acknowledged that he looked really confused during the proceeding, during his plea. And he said, I don't want to plead. He also asserted innocence. He also said, I don't want to plead guilty to something I didn't do.
All
This-
that, now, do I have this right in terms of the record? All that was leading up to what ultimately was a plea, right?
Yes.
And so you're saying, looking back, he's exhibiting all of these indications that it's not a willful voluntary plea. But at the time of the plea, don't we have these instances all the time where a defendant says something during a plea colloquy and the judge says, whoa, I can't take the plea, and the attorney jumps up and says, hold on, let me talk to my client, and they take a break, they call the case later, and they come back up, and now the plea is taken, right? So my question here, though, goes back to, I think, following up on Justice Curran's question. We've got a written plea waiver here, right? And I think this is one of the examples of the waivers that follows the model colloquy. It has the information all in there that the Court of Appeals has told us we ought to be using this, right? And in this particular case, on top of that, the judge inquired of the defendant whether he understood the written waiver. So if we get to the point where we say the waiver's good, and there's been a waiver of appeal, what is it that survives in your estimation in terms of this appeal?
So I do think that under those circumstances that it would be an ability to withdraw his plea based upon the voluntariness of the plea. I also think that you also have to look at it in conjunction with CPL 245.25 in relation to the valid waiver of his discovery rights. Obviously, the discovery was a particular issue in this case. There is a, similar to the written plea colloquy, there's also a written discovery waiver colloquy that never took place in this case. And because of that, that's kind of here we are.
Well, I think we have that argument, counsel. Anything further?
Nothing further, Judge.
Very good. Thank you, counsel.
Good morning, Your Honors. Marty McCarthy for the people. We just discussed this in the previous case regarding the forfeiture of the very things that he's...
We have recent cases that hold exactly that.
And that's true, too. And that doesn't even take into account the waiver of appeal. That's just, we're talking about forfeiture at this point. So absent the waiver of appeal, most of the claims are still forfeited at this point. Or they're unpreserved because they were never made below in the first instance. And with respect to the waiver of appeal, yeah, it was a model colloquy. For the longest time, I've been coming up here and arguing about how our appeal waiver was wholly inadequate, because it was. We finally got the message. It took a very long time, but we use the model colloquy now. And not only that, but the judge also made a separate inquiry about both understanding the written waiver and also asked questions about the waiver of appeal. The waiver of appeal, in this case, precludes every single instance of the defendant's arguments that he's trying to make now. If there are no other questions of me, I'll rest.
Thank you, counsel.
Thank you.
Case 778, People versus Martinez. Mr. Keene, proceed.
Thank you. Brad Keem, I represent Linda Martinez. We assert that Linda was deprived the effective assistance of counsel. We recognize that the Second Department in People v. Hudson, they determined that the DPSJ hearing can be waived, but this case is much different than Hudson because defense counsel in Hudson requested a DVSJ hearing, and then the plea offer explicitly required Hudson to waive that right to the hearing. Here, Linda never waived her right to a DVSJ hearing. The prosecutor only mentioned that the disposition was reached in part due to Domestic Violence Survivors Justice Act. It was never clear that defense counsel waived the right to such a hearing, or that she was even given consideration for the waiver of that right. So why is that ineffective? That's ineffective because defense counsel explicitly said at sentencing that the law was applicable to the facts and circumstances of this case. So defense counsel knew that it applied or believed that it applied and did not attempt to request a hearing for her. That we would assert is ineffective assistance of counsel. In Liz L., the third department, they stressed that it does not matter if, for DVSJ purposes, if it's a plea of guilty or if it's a trial, DVSJ applies equally to both. So that whether defense counsel was a super lawyer or had a good reputation in the community, which are things that people stress, that does not matter. This was a single error that potentially deprived Miss Martinez of the ability to utilize the statute, to reduce her term of imprisonment. In the brief, we go to great lengths in explaining how she, even on this record, met the requirements of DVSJA, which further demonstrates why the decision to fail to request a hearing was ineffective. But if this court has no questions on that issue, I will rest unless there's other questions about the waiver or preservation.
Yeah, let's address the waiver just briefly. Why doesn't the waiver apply here?
So the waiver does not apply because it infected Linda's choice as to whether she could waive her right to. She didn't know that the DVSJ hearing would be part of the waiver. And the DVSJ hearing is really fundamental and non-waivable part of her right to be sentenced in accordance with the law. So first, we would argue, as we did in the brief, that the waiver is invalid. But second, even if the waiver is valid, the DVSJ hearing is her right to be sentenced in accordance with the law, and that is fundamental and non-waivable in our claim.
The written waiver seems to be an absolute bar, uses that language. Does the court's oral colloquy cure that?
We would argue that it has to be taken in the totality. So there are aspects of the model colloquy that are used, but not all of them. The court didn't use all of the exceptions as the model colloquy asks it to do. It didn't mention jurisdictional issue, competency, speedy trial, things of that nature. So with the problems with the oral and obviously with the problems with the written waiver, when taken in the totality, we would say that the waiver itself is invalid.
Thank you, counsel.
Good morning, Your Honors. Michael Tantillo for respondent. Initially, it is our position that the waiver of appeal resolves this case right at the outset. The court followed the model colloquy almost verbatim, and you're right, Your Honor, that the written waiver is more boilerplate and does not track the model colloquy, but there is abundant case law that indicates that that may be cured by the oral colloquy, which in this case was, I would submit, essentially perfect and followed the model language. So right off the bat, it's our position that that ends the matter. Regardless, we take the position that there was certainly no ineffective assistance of counsel. There was very effective assistance of counsel in this case, including counsel's repeated efforts to get the trial court to provide funding for him to hire a psychiatrist and or a psychologist to assist him in determining whether he had viable defenses available to him here. That ultimately was done. Counsel indicated that he had met with the psychiatrist, that they had reviewed all the defenses, they reviewed that with the defendant, and made an informed and conscious decision that this plea bargain, reducing the murder to manslaughter for 8 years, was the best possible outcome they could seek. I see no basis from which to draw any conclusion other than the defendant received very effective representation. Now, counsel mentioned People versus Hudson in his statement. If the court's not aware of that, that was a case decided just in the second department just last month, which dealt with some of the very same issues here and concluded that a penal law 60.12 hearing, DVSJA hearing, may be waived, that it is not required. And I'm not sure if that has been provided to the court, but under the court rules, I would be happy to provide a copy of that case within 5 days from submission
Counsel,
today.
I think we have it.
You have that already, very good. Thank you very much, Your Honor.
Thank you, counsel.
You're welcome.
Case 780 and 781, People versus Howard. Proceed, counsel.
Thank you, Your Honor. There's two indictments in this case, and our position in point one, which I'm going to focus on here today, is that all of the evidence supporting the first indictment in this case was seized as a result of an unlawful and unconstitutional search of my client's home and papers. The record is clear that the officers entered pursuant to the limited emergency exception. There was a domestic disturbance call, and they went inside. We don't dispute that that was allowed. While inside, they quickly confirmed that the girlfriend, Jasmine Yomis, was all right. She did not want their help. She did not want to press charges. The only officer who was there at that time, Officer Rivera, testified that it was within a couple minutes they resolved this, and that was before he even went back and looked at the papers that are at issue here. After that point...
Can we stop there
Yeah.
for just a minute? Rivera is the first one on the scene, correct?
Rivera and his
Because
field training officer, Wassinger. both
Only
of them.
because I think sequencing is important here,
Yeah.
because later on we've got to tie together the footage that we have.
That's right.
So he does testify at the hearing and says, I did see the checks laying out, and I thought something was up.
Well, I don't remember him
He
saying I
couldn't say
thought something was up, but he did.
He said
said
something to the effect, I wanted to alert the senior officer on the scene that there was something with these checks.
I don't recall testimony to that effect, but he did say, I noticed them as I went in to talk to.
I was alerted by these checks. I was alerted.
He saw them. He also confirmed afterwards what they were, so I don't know how much they stood out to him or not.
Okay.
What the video shows, though, is Officer Wassinger standing after an initial sweep into the kitchen and then back to the living room. He's standing by the couch. Other officers are inside talking to Ms. Yomis.
I'm sorry to interrupt you, but
Okay.
that's my question. That video happens after the checks are first viewed by the first officer on the scene. We don't know what happens between the first officer identifying these checks and reporting it to the senior officer, how quickly Wassinger gets to those checks, and because I know your position that the video shows his hand reaching into the pile of checks.
Mm-hmm. Right. I mean, we have the video that appears to be Rivera and Wassinger entering the building together. Wassinger is his FTO, his field training officer, and the two of them go in at the same time. We see, apparently Rivera goes into the bedroom, and Wassinger sweeps the house and comes back to the couch. I don't see any place in that video where you could see communication between the two of them, or I don't know what significance it would be. What we see is, eventually, Wassinger is standing there by the couch, and he suddenly decides to flip on his flashlight and start looking at, they never come into view on his camera, but he starts looking at the checks there. Right.
So, counsel, let me ask you a question. So the officers, you concede that the officers initially are properly in the apartment?
Yes.
Okay. Your argument is that within a few minutes, the reasons for them being in the apartment have expired.
Yes.
And what is it that they should have done at that point? Simply leave?
I think they have two choices. If they had probable cause based on what they'd already seen, they could grab the checks and seize them. If they had probable cause based on what they'd seen, they could leave and apply for a warrant. I might concede that there's a third possibility, that if this was something complicated to seize and it was a sensitive situation, there might be a limited time frame where they could get an evidence tech in there to seize it for them, right? But what they did was not on any of those things. What they did was they called an investigator. And Officer Rivera's testimony is, I called an investigator because I didn't know anything about financial crime. I didn't know what I was looking at, right? And so we called Investigator Rodriguez. And Investigator Rodriguez came in, and he didn't come in for the purpose of seizing the checks. I mean, ultimately that may have been his purpose, but instead he questioned Ms. Yomis about it. Ms. Yomis has already told the police, I'm done, I don't want to press charges, I just want to leave. And now he's conducting an investigation of her into this separate crime, and I believe that clearly overstayed the emergency
But
exception.
Mr. Hobbs, your fundamental point, as I understood your brief, was that the violation occurred before Rodriguez even got there.
I mean, I think there's two ways we can get to a violation, right? The opening brief focuses on what happens before Rodriguez gets there. I mean, I address both points, but yes, I believe that the officer spent too much time, didn't show that they had probable cause based on the appearance of the checks immediately. Instead, they're reviewing them, reading them, going through them, right? And it's the people's burden of proof here to show that they had probable cause based on the immediate appearance.
Didn't you argue in your brief that the video, and I forget if it was either Gullah or Wasserman, I think it was Wasserman's video where you can hear the rustling through papers at the time?
Yes.
And then you also pointed out, as I think Justice Del Conte mentioned a second ago, to the effect that it looked like maybe the body-worn camera, maybe you mentioned it, that from Officer Gullah, that the last scene, right when the video is cut off, is you can see Wasserman's hand down there.
That's correct. Yes,
So
and then all of a sudden,
that's the basis of your argument, that that's when that became a search without a warrant. And, you know, they were clearly beyond the point of just a simple seizure under the plain view.
that's correct. I mean, I can concede that, you know, I'm interpreting what the video shows here. The video is the shot of Wasserman's hand touching the papers. Looks like he's going through it, but it's very brief. And the sound is open, perhaps it's open to interpretation, but it sounds like rustling to me. And it's the people's burden of proof. These things raise questions that they were required to show they did not conduct this kind of
And
search.
neither Gullah nor Wasserman testified at the hearing.
That's correct, right. These would be the people that would best be positioned to know what they did with the papers. Rivera expressly testified, I don't know what my fellow officers did with the papers. I don't know whether they touched them, I don't know
He
whether they
said,
moved
I'm
them.
not well-versed on check-type stuff. That's the quote I was looking for.
Okay, yes. That's the one that supported his policy.
Counsel, let me ask you a
Yes.
question. With respect to the plain view, the extent of the plain view doctrine, in other words, what they're able to look at once they're in the apartment, is it your argument that they would have to be moving things around? In other words, disturbing what could readily be seen without moving anything in order for them to be violating this? Or is it enough that when they're in the apartment, for purposes of a domestic violence call, that they go over to, say, a desk or a table, sit down and start reading documents? Are those documents in plain view if they sit down and start reading them?
My position is no, they should not be reading the documents, and that goes too far. I think the case law is a little bit vague, and different cases come out different ways, and I've cited a number of federal cases that address documents to get a little bit more, financial crime and in the federal case law. But a lot of those cases seem to suggest once you're reading the documents, you've gone beyond what you can do on plain view. I mean, I think if you had a sign, the bold print, and you could just see it from across the room, that's plain view. But if you have to sit there and hold the document up and start analyzing it.
In other words, plain view is, I see checks, but I have no idea who they're written to, what they're dated, what the check number is, or how realistic they look.
Right.
I just see that there are checks.
Right.
But your position is, as soon as they go over, sit down and start studying the document, that's not what plain view was intended for.
Yes, that's my position, and I believe that's what the video shows, is him reading the check saying, oh, there's a whole bunch in the same name. Oh, they're in the same amounts.
So we don't even have to get to the rustling and the moving of documents if you're right on that point.
Correct. Right.
Anything further, Counsel?
I just wanted to say a bit about the relief, if I'm right on this point. I pointed out that the second search is pursuant to a warrant, which incorporates information from this seizure. I think the court has to make a determination whether the warrant for the second search is adequate without this, the information from this first search and seizure. It's the sort of independent source analysis. There is other information in that warrant, and, you know, I think either the warrant is tainted, or if it's not, I still think that a new trial is required on the second indictment because of the extent of this evidence, which included laptop that was seized in the first search. Wouldn't have any confidence in the result of the trial if you separated out this evidence. So I think the first indictment would need to be dismissed, and the second indictment, at the minimum, it's either dismissed because the search warrant is invalid, or we get a new trial. And unless there's any other questions on the other points. Thank you.
Good morning, Your Honors. Martin McCarthy for the people. Justice Del Conte, I think you had the sequence correct with respect to the way the officers went in and what they observed and when they observed it. I believe you stated that officer.
Counsel, could you speak up just a little bit? I'm getting
Sorry.
older, and
Normally, I'm pretty loud. I don't know what that was about.
I would agree.
I think it was intimidated by Justice Del Conte. I believe you have the sequence correct, Justice Del Conte, with respect to Officer Rivera coming in first. Seeing in the testimony was he immediately saw checks. I believe you accurately reflected what the testimony was, and then Officer Wassinger comes in with and the body camera gets turned on. His body camera gets turned on. So when you talk about plain view, right? There is what Officer Rivera saw first, right? He saw checks. And then you take into account what's captured on that body cam. It's clear that these officers know the defendant. The defendant knows them. In fact, they have an interaction talking about.
But at the hearing, did anyone argue that for the people?
I don't know if they argued that for them. And
I don't remember it in the record, Mr. McCarthy, personally, but maybe it's there. I'll take another look.
It's certainly in evidence. That's certainly in evidence because it's clear from the body cam that you all have seen and you've accurately recounted during the argument. It is clear that the defendant knows the officers know the defendant. So when you talk about what the officers know, they know who he is, right? And they know what he doesn't do. He's not in the payroll business. So that is why when you look at those checks.
That's a large inference from that video, Mr. McCarthy, I have to say. Again, if you want to disagree, tell me why.
That's a large inference?
That's a big, I guess it's a big leap in my view. Yeah, they're talking to the defendant. For all we know, they know about it for something completely unrelated to checks. I mean, that doesn't link it to the checks. And again, I don't know if that was argued then, but I'll look at it. But it seems to me, arguing now that your primary point, something that I don't think really was emphasized at the hearing by the people at all, if even mentioned. So now you kind of, so I'm having trouble with that argument.
Well, when you look at the three requirements for plain view, one of them is that the criminal nature of the articles are immediately apparent. Well, how do those articles become immediately apparent that they may be criminal in nature? Part of that is the knowledge that the officers have with this particular defendant.
You first, please. Thank you.
That's where I'm struggling with this a little bit, Counselor, in the sense that as I read the hearing testimony, Rivera is the only officer who testified. Rodriguez testifies, but he comes on later. But yes. Rivera is the only frontline officer. And he doesn't say specifically, I knew those checks were a problem. I knew that those checks were evidence of a crime. He says, I'm not sure. And there isn't any testimony from Wassinger or the other officer, Gupta or Gula, on that issue, right? Mm-hmm. I mean, where in the record does any officer say, I knew when I saw those checks that it was a problem, they were bad?
So when you look at plain view and you look at this record, I would say that there is no direct testimony of that. You would have to infer it if
because that's
you
the
said,
problem.
Justice Kern, maybe you won't.
Just to follow up, but that's the problem, because then the next piece of evidence we have is the body cam footage showing one of the officers reaching down, and we hear the rustling, and they're making a closer examination of these checks and
potentially, yeah,
manipulating these checks.
I would call that an inference. I would call that an inference. I would not call that an established fact either, though. Right. That's an inference that the defendant is asking you to make. Maybe that's an easier inference for you to make than the one I'm asking you to make. But that being said, when you there were two bases for the seizure in this case, the plain view and the second, ultimately, was also consent, right? So when you look at plain view, and you look at the reason, and I believe you brought this up, Justice Whalen, the reason why they're there for a domestic call. And yeah, domestic violence victims say they don't want to prosecute, but they did independently observe evidence that some sort of assault occurred. I mean, the defendant was bleeding, or he had blood on his shirt. So they needed to investigate that call. They were allowed in the house initially. Once in the house, maybe it goes to the fact that you look at those checks and you say, as you point out that Justice Del Conte, that Officer Rivera said, he's like, these don't look right to me. I don't know what they are, but they don't look right. Let me get somebody that they might look right to. And ultimately, they bring in somebody and they obtain consent to seize those articles. So there's the additional basis of consent. And the question is could they have asked for consent in that scenario? I think the answer is yes, because they were lawfully in the apartment at the time. That's undisputed. They viewed, at least initially with respect to Officer Rivera, he viewed what he saw from a lawful vantage point. He didn't do anything. There's no evidence he did anything in terms of manipulation of anything, papers, what have you. That, to me, is enough to then proceed on a theory of consent to continue the encounter, right? Because there may be a reasonable suspicion that criminality is afoot here. That was not, oh, hey, well, you saw what might be fake checks, time for you to leave. I would not say that at that point they were obligated, as defense counsel's arguing, that they were obligated to leave, because I don't think they were. So even if you were to say, okay, this was not, you can't uphold the search on the plain view doctrine, you can uphold this search based on consent.
We'll take a look at that, Counsel.
Is there no other questions?
Thank you.
Thank you.
Case 783, Rook versus Dibble. Counsel, can you hear us?
Good morning, Your Honors. James Alexander for Appellant.
Very good. Counsel, can you hear us?
Yes, I can.
Yes, I can.
Very good. Let's proceed.
Thank you. Your Honors, we submit on this appeal that the lower court erroneously dismissed the plaintiff's 2 motor vehicle accident claims on the issue of serious injury and committed reversible error in doing so. The defense relies upon the defense doctor's report here, and notably, in 3 respects, reversible error was committed. First, the defense doctor stated that my client only sustained minor cervical strains as a result of these 2 motor vehicle accidents, strains that would have resolved themselves within several weeks. And yet it's conceded and pointed out throughout the report that my client has been continuously treating and symptomatic ever since the motor vehicle accidents, 5 years worth at the time that the motion was decided, now 6 years, and that there have been consistent findings of severe limitation in the ranges of cervical motion.
So, Counsel, let me ask you this. Just on that point alone, are you suggesting that on the serious injury threshold issue, that in the defendant's expert affidavit itself, that the burden never shifted because there was enough information contained in that report and in the motion that raised a question of fact for the jury?
I do say that, Your Honor, and specifically because the burden is on them when those facts are present to explain why it isn't due to the car accident.
Let's assume for the sake of argument that on this particular case, now just by way of procedure and how we're going to go about this, I've just called the 783 case, I'm going to call out of order 788. So we're going to follow this case up with 788. So have that in mind in terms of your argument. But with respect to the 783, which is the December accident, do I have that right?
Yes,
As opposed to November.
Yes.
Let's assume for the sake of argument, and I know you're not conceding this point, let's assume for the sake of argument that defendant did meet their burden, and we find that the burden shifted to the plaintiff with respect to raising a question of fact. Is it your contention that if we go down that road, that your expert affidavit, Dr. Swearengin, do I have that right?
You do, and I absolutely agree with that.
Would have raised a question of fact on serious injury?
Yes.
Okay. Where is it that there's evidence in the record on raising a question of fact from Dr. Swearengin, where Dr. Swearengin indicates that there was a injury that was either exacerbated or by itself that arose out of the December accident? Do you follow my question?
Yes, the December accident was the second accident, and there's indication in the medical records that there was an exacerbation of the condition from the accident 2 weeks before.
Let me ask you this question. When we say exacerbation, and forgive me for this, but when we say exacerbation of the condition, let us take a look at the overall facts of this case in terms of there is evidence in the record that demonstrates that the plaintiff did treat prior to the November accident and had some medical condition.
Yes.
Then she has the November accident. Shortly thereafter, the December accident. So my question is, when you say an exacerbation of the condition, are you talking about an exacerbation of her condition that was in effect in November that related to the November accident, or an exacerbation of her condition that preceded the November accident, and does it make a difference?
I understand, and thank you for that question. The previous treatment, the plaintiff was primarily treated for her low back by her chiropractor prior to the both motor vehicle accidents. He occasionally noted that she complained of neck pain, but Your Honor, there never were any diagnostic tests done, no x-rays, CAT scans, MRIs. There never was a finding of restricted range of motion. There never was a finding of displaced forward head position as there was immediately after this accident. And she didn't lose any time from work. She didn't need any remedial work modifications before this accident. So she did complain occasionally, intermittently, of some neck pain and stiffness beforehand, but it was rather benign. That became very serious after this first accident in November and the second accident in December. After those motor vehicle accidents, there were consistent findings of severe restriction in the range of motion cervically in all planes. There was consistent findings of spasm. There was a consistent finding of a displaced head position consistent with ligament damage, which was then objectively shown by a digital motion x-ray. So the record is complete.
Counselor, I'm sorry, let me interrupt you. Let me follow Justice Whalen's question if I could. So let's assume that the defendant has shifted the burden, okay? Would you agree with me that the plaintiff then has to respond in each of those accidents to raise a question of fact as to causation? That the plaintiff has a burden to show that the first accident caused a serious injury, as well as establishing that the second accident caused a serious injury or aggravated in some way the first accident's injury. Do you agree with me with that?
I agree in part, Your Honor. However, when two accidents contribute to a serious injury and it can't be determined whether it was all number one or number two or some combination, I think the burden then again switches to the defense to say that it's not. Our position is that these two accidents cumulatively created a serious injury and met the threshold.
So as I read the record, though, I don't see Dr. Swearingen giving an opinion that the second accident itself, isolating the second accident, either contributed to the injuries that resulted from the first accident or aggravated the injuries that resulted from the first accident. He doesn't give that opinion, does he?
I think that he does. I'm looking right now, and he does state that both accidents, he says he can't determine which one contributed more to the overall serious injury, but that both did, and both provided the mechanism of injury to the cervical spine.
Right. Because as I understand what the defendant in this case is saying, that Dr. Swearingen establishes at best, if you credit his opinion, that the plaintiff suffered a serious injury as a result of the first accident, and Dr. Swearingen doesn't get you over the hurdle to show that there's a second serious injury in the second accident.
Judge Del Conte, even if we were to assume that's true, I have to say that the defense failed to meet their burden by not explaining why she's been symptomatic and in pain with these objective findings for 5 years at that time, and why he can't explain that the digital motion X-ray establishes ligament damage, which he does, which he apparently implicitly concedes, but does not attribute it to anything else. And perhaps most importantly is that he finds severe restriction in cervical range of motion in all planes on the date of his exam, and he doesn't explain why that isn't related to the car accident. This court has ruled numerous times that any of those are a basis and are reversible error.
Anything further, counsel?
No, thank you.
Counsel?
Good morning, Justices. Respondents are respectfully requesting that the decision be affirmed, but just to jump into what we're talking about here, it looks like whether or not plaintiff or appellate was symptomatic prior to the accident is what's most important for the court here. And we will respectfully disagree with appellant's counsel here and point out that Dr. Castellani in his IME addendum goes blow by blow through year after year from 2008 up to just several months prior to the accident, in which he is showing symptomatic neck pain, shoulder pain, as well as bilateral hand numbness that she treated for in those years. Specifically, there was a diagnosis after a workers' comp injury just a couple of years before the incident with segmental and somatic dysfunction of the cervical region. So it's not as if this treatment that she was undergoing over this time was due to no symptoms at all. Why would you be treating and getting these diagnoses then? And on the subject of diagnostic reporting, appellant's counsel has made issue of there not being any diagnostics prior to the accidents. Well, actually, there was a diagnostic after the accident. Dr. Horgan, appellant's treating neurosurgeon at the time, opines that it was a negative MRI, a negative cervical MRI, and he determined she had no need for further treatment. It wasn't until 3 years later that she follows up with Dr. Swearingen and starts complaining of her symptoms that she had that was ongoing. Now, Dr. Swearingen does state in his report that she has symptoms, and he does attribute it to both prior accidents, but in no way does he address the fact that she had over a decade's worth of treatment for neck pain, shoulder pain, and bilateral hand numbness before the incident, which is very interesting considering he was with the practice that she was treating at the time during that time period. So,
Mr. Minahan, real quick,
Yes.
for my sake, this is how I've crystallized your argument, but I want to make sure it's fair, and if it's not, please let me know.
Sure.
As I read Dr. Simonelli's affidavit or report, whatever, he essentially says these were all injuries, soft tissue injuries that were all resolvable or should have been resolved in 3 weeks for both accidents. And that's how you carry your burden. And he explains away the long duration of treatment that plaintiff relies upon because she is reporting self-limiting injuries. That is, I equate it to she's making it up. Is that a fair statement of your position?
Yes, it is to some extent. It's Dr. Castellani's opinion that the trapezius and the cervical injuries were soft tissue that resolved within 3 weeks. He found that there was no causal relationship for the bilateral hand numbness or the left hand numbness for the carpal tunnel syndrome. But otherwise, I do agree with that opinion. And he does base that heavily off of the records he reviewed that were the basis of his addendum.
Thank you, counsel. Anything further?
No, nothing further from me. Thank you.
Very good. We'll now call case 788. Rook versus Irene Wood.
Attorney James Alexander for appellant.
Attorney Jonathan Dominic appearing for defendant.
Very good. Counsel, proceed.
Thank you. I need not reiterate our position and arguments just made, but I would add to it based upon defense counsel's last argument that this defense doctor, Castellani, never related her conditions to anything. He did not say it is due to degenerative disc disease, it's due to her previous treatment. He simply didn't comment on it other than to say she should have only had symptomatic problems for several weeks after this accident, when in fact she had problems for 5 years, now 6 years consistently. And there is objective findings, including a digital motion x-ray that has been unrebutted, showing ligament damage injury, which also correlates to the very forward head position that has been noted, forward head displacement, that was found shortly after the first accident and has continued for years afterwards.
Counselor, if I can follow up on that, we have a little different situation here because this defendant is the first accident. And Dr. Swearingen says, and I think that there's a substantial loss of range of motion as a result of the motor vehicle accidents, which he's really relating to what happened in November, correct?
He does. It started and continued ever since the November accident.
Right, because she treats after November for the cervical injuries.
Yes.
And this defendant doesn't raise or can't raise the same argument because they're the first in time. Your position is, and your expert opined, that as a result of the accident, she suffered an injury to the cervical ligaments, which required treatment of serious injury under the insurance law.
Yes.
Yeah.
You don't have very true. And also missing from her the records that the defense doctor refers to regarding prior accidents are nowhere in this record, which is insufficient to support the doctor's opinion as well.
Very good. Anything else, counsel?
No, thank you, Your Honor.
Counsel?
Thank you, Your Honor. May it please the court, addressing Your Honor Del Conte's comment, the amount of treatment following the two accidents is determinative here. With regard to this first accident, there's 2 visits to the chiropractor on November 28th, 6 days after the accident. She's already reporting that she's feeling much better. Every medical record after that point is attributing her issues to the December 7th, 2018, the subsequent second accident. Just
a minute. I know you're making that argument, but that's not in the record. Castellini's opinion came in the first motion relating to the Dibble defendants. As I read the records in both appeals, you in some ways piggybacked on his affidavit. You don't raise the causation argument in your case. You don't make the argument all these injuries were caused on December 7th. As I understand your argument, you believe, based on Castellini, that these are all pre-existing problems, pre-existing the first accident.
That is part of the argument, Your Honor. However, there is also the position, and it is in the medical records that were attached to the motion, that subsequent medical records are they're part of the December 7, 2018 no-fault file. That's what she is When she goes to the doctor, the report of injury is, she's stating these happened in December 7, 2018, following this car accident. She doesn't attribute to the doctors that these are injuries related to the first accident. Similarly, when she goes to the emergency room, she's complaining of injuries to the same body part and saying that these are all significantly worse. It's also consistent with her employment records that she returned back to work after a few days, full-time without restriction. It's also consistent with Castellani's report that there are no objective findings. And that's enough certainly to meet the primary burden of proof. Now, in terms of whether plaintiff can raise a question of fact with Dr. Swearingen's affirmation or affidavit, he cannot, simply because, for the same reasons, there's no effort to distinguish between pre-existing medical issues and post-accident issues. And there's also no effort by Dr. Swearingen to distinguish between the two accidents. There's nothing...
Wait, I'm sorry, I get that, and that was raised by the Dibble defendants, but I don't see that anywhere in your brief that you make the causation argument as it relates to the second accident. Your argument on behalf of the Wood defendants is that all the issues that she has were pre-existing the November accident. And Swearingen, I think, opines that she has serious loss of movement in her cervical region as a result of the accident.
It is, I apologize, Your Honor, that I can't point to the specific page, but as I recall, it is mentioned in our submission that Dr. Swearingen does not distinguish between the two accidents, in addition to the causation argument that is, as you stated, very much preserved and is the sub-argument as well.
We'll take a look at that, counsel. Is there anything further?
No, Your Honor, thank you. If there are no questions from that.
Thank you. Case 784, Lee versus Quida Health. Proceed, counsel.
Good morning, Your Honors. Hetty Arletta of Roach Brown for the appellants. If you don't need an explanation or a summary of the facts, I'd like to go right to the question of whether the defendants met their initial burden to make a prima facie case. The trial court said no. However, defendants produced the sworn testimony and the medical record, which provided the factual support for their expert, who said there was no deviation from the standard of care on the part of these residents. The plaintiff said, well, there's a hearsay statement somewhere in the record that...
Ms. Arletta, pardon me real quick, just a quick thought, and don't lose your train of thought, because it'll be an easy
I
question.
will lose my train of thought.
What's that?
I will lose my train of thought.
Sorry about that. But are you representing Dr. Chia on this appeal?
Your Honor, thank you for asking. No, Dr. Chia's been let out.
Okay, so
And
we
I
don't
was-
have to grant any relief vis-a-vis Kaleida for Chia's actions?
That is correct. And we never represented, he was always separate, and they let him out voluntarily.
Okay, so you represent the three, that's what brought it to mind. You just said you represent the three residents. Carter,
Actually-
Scheffner, and the other one I can't pronounce, I'm
I
sorry.
can't pronounce it either, and luckily for us, she also has been let out.
But could the Kaleida nevertheless be liable for her actions, even though she's not personally liable for the damages?
No, not in this case, because the plaintiff let her out on the merits forever and ever, and so she cannot be attributed, no negligence can be attributed to her, so it can't be attributed to the hospital.
She can't be on the verdict sheet and then Kaleida be responsible for it?
I don't believe so.
Okay, got you off your game.
I'm going right back. Okay. So, prima facie case. The fact that there's a hearsay statement from the son of the plaintiff that says, oh, Dr. Chia told me he thought...
Let me do it again.
No.
I'm sorry, but this interests me very much, and I won't belabor too long, but you say it's hearsay. You attach the entire deposition transcript of the son with all that purported hearsay to your motion papers. So that's like going to trial and putting it into evidence. How can you then turn around and say, it's hearsay? See, that just strikes me as odd.
No,
So you put it all
sorry.
in yourself. No, I talked over you. You did nothing wrong. So, but so that's what, see, in any event, it's probably an admission, there's probably admissions vis-à-vis Kaleida in any event. Because Chia then is under the vicarious liability when he says those things for Kaleida, is how I view it. So you tell me it's hearsay doesn't help me. That's what's on my mind, Ms. Aletta, when you bring that, and I wouldn't mind hearing your response.
Okay, I really wasn't anticipating that because the law is, well, first, on a practical level, then, is a movement supposed to say, well, I want to put in all the testimony, but I better rip out this page because it's hearsay and I don't want the court to think I'm accepting that hearsay. There's case law right on that that says, no, putting in a transcript is not the same as saying, I agree with everything that's in there, I'm validating that that statement is in there. That's not how it works. You're entitled to put in your evidence.
We might have a case called Shaw, I think, that might say to the contrary.
If I may,
I'll look at that.
after the argument, may I have time to put in a case that says, no, putting in a transcript does not mean you're validating or accepting or admitting the hearsay? Do I have would you allow me to do that?
Is that the Watson case you're referring to?
It sounds familiar, honestly, though I can't tell you
Yeah.
right now.
Yeah, you're welcome to submit a case.
Thank you.
Yeah.
Okay, so if we could assume for the moment that hearsay is not a reason to even so, remember what stage we're at, prima facie case. We've put in the evidence, we've put in the expert, he has facts to support it. We don't look at what the plaintiff might say at this stage. We should have been given the okay to go ahead because we've made our prima facie case.
Let's stop there too, Ms. Aletta, for my benefit. I've got your brief here, and I need to take it what maybe is the tail as opposed to the log, but reading your brief on the lack of informed consent cause of action,
Yes,
the only argument I see here is that consent was given in your brief.
two arguments.
I don't see that in your brief, and that's why I'm raising it.
It might be in the reply brief, because the other argument is the plaintiff didn't reply, and so they abandoned the claim.
We'll cover that in a second, but looking at your law, because below you made two arguments, that is, it's not physically invasive. Whether or not that matters here, because physically invasive only matters when the plaintiff is claiming that you didn't do something, and therefore you don't need consent. Because when you didn't do something, there's no physically invasive procedure. And, two of your residents call this a procedure in any event, but putting that aside, just so you know, the way I read your brief, I don't see you attacking that physically invasive argument that you had below. I just read it as saying that, that the residents got consent.
That's what's in the brief.
Okay.
And then, when they put their papers in, they abandoned it.
And with respect to the argument you make in your brief about Bubar, which you have since clarified, I think, in Carroll, you don't cite Carroll, but the Bubar argument was raised for the first time at appeal. You didn't argue partial summary judgment or Bubar or abandonment, whatever we call it. That was not in your motion papers, including in the reply, correct?
Well, I believe it is in the reply.
I looked.
If you say it's not there, it's not there.
Okay.
But,
Well, I've got a lot of cases on too, like you do, but
okay, I thought that the
I'm just letting
tail
you, I
end...
don't see it. I'm sorry, I've talked over you again. I apologize.
That's all right. They abandoned not only that one, but the direct claims against Kaleida, our expert, addressed them. They said nothing. And I don't know if it has to be spelled out in the brief. We put it in, they say nothing, they've abandoned it.
But when you don't move for partial summary judgment,
No, because I want total summary judgment.
well, you could also move alternative for partial,
I know
right?
it.
And none of that happened. You didn't cite Bubar, you didn't cite Carroll at any of the papers below. So that's a problematic issue for me in any event.
We cited Bubar. I know I cited Bubar. For what point I cited it, I can't remember right. I know I cited Bubar. May I continue? Okay.
Of course.
Thank you.
Thank you. So, the prima facie case aside, what is the claim by the plaintiff's expert? They deviated from the standard of care. First, because these residents had the audacity to change the treatment plan. They disobeyed the order for Santel, and they went ahead and did what they wanted to do, which was this manual debridement. That's the plaintiff's theory.
They were arguing that the residents chose the wrong course of treatment under the circumstances.
No.
And here the best, I think, that the residents have is that they made an error in judgment, if
No.
any.
No, respectfully, Your Honor.
Go ahead.
In fact, that's what I wanted to emphasize. If you read the plaintiff's expert carefully, he is not saying, oh, that was the wrong thing to do, it wasn't called for, other than the fact that there was an order for Santel. You shouldn't have done this on this man. The amount of the granulation tissue was not such that it should have been manually debrided. He doesn't say that. He says always and only, and I put out 5, 6 examples from the plaintiff with italics or whatever. They disobeyed. They countermanded. They didn't give Dr. Chia the courtesy of telling him what they were doing. Not, that was the wrong thing to do in and of itself. They're not saying that. And yes, it was a judgment call. But his thing is, you disobeyed the Santel order. I can try and, there's a page that lays out what the expert says.
Well,
You
the inferences
disobeyed.
here favor the plaintiff, don't they? That is, the surgery to repair this ruptured colon was on December 20th.
Correct.
He remains on the ICU for about 10 days or so, and I think somewhere in there gets the wound vac. Maybe it was after when he
had
got to
the wound
the
vac.
surgical floor. But it's not, and then on January 5, Dr. Chia says that the wound is healing well. And then the next morning, they show up for the first time ever, they see this patient, and they conduct a debridement. And one of the residents says that was just relying on chemical debridement was the wrong thing to do.
Regardless of what he said, the fact is, first, this is not a rocket science-y thing. The chemical debridement is ointment you put on it. The manual is scraping off the stuff and picking it out. So it's not a surgical procedure. But the real point with
It
the
is a
first...
procedure, though, right?
Well, I don't know what else to call it. I mean, it's a thing. It's something they do.
It's a treatment, it's a procedure, and both of those are required, informed consent's required for both of those.
Which was given. Okay.
Gotcha.
So, but this first deviation has to do with not, though that was a real bad choice, you can't have hindsight. Besides, that's not what caused it. It was disobedience, is what he's saying. And what the plaintiff's expert doesn't do, he says, oh, there was a Santel order, and Dr. Chia was perfectly happy with it. In fact, Chia saw him the day before, as you said. He was perfectly happy. But the 3 residents, they're not medical students, they're residents, they're doctors in their own right. They said, we had the perfect authority to do. That's something we can do. And Dr. Chia, their supervising attending doctor, said, yeah. And I cited this a couple of times because it was so important. He said, yeah, I figured Santel would be continued, but those doctors were at the bedside. They're the ones looking at the thing. They decided if they should have manual debridement. It's their judgment call. He said that. So for the plaintiff's expert to say they had no authority, and that's a deviation from the standard of care, that's entirely subjective, entirely unsupported. 3 doctors and their supervisors say, sure you could. You're looking at it, you decide. So that aspect, the disobedience aspect, is wrong. The residents also said, we don't call the doctor on rounds, we call him after rounds and tell him what happened. And in this case, Dr. Chia countersigned the note that said, we did a manual debridement. He had no problem with that. The Santel...
Counsel, be mindful of your time.
I'm sorry.
Be mindful, yeah.
Yes, thank you. Just the Santel order itself didn't say, this can never be changed. Don't do anything but this. Okay. The other deviation is the procedure itself, which applies only to Dr. Schaffner. Dr. Carter was out of the room, and they don't say that was wrong. Dr. Schaffner, plaintiff says, oh, you must have cut the suture, you must have cut the fascia. This plaintiff expert has no physical evidence of that, no sworn testimony of that, no support in the medical record of that.
You're saying it's speculative.
Excuse me?
You're saying it's speculative.
Well, yes, and based on falsity. So the plaintiff expert explains why he says that. Well, Schaffner was cutting and digging Schaffner's the only one who addressed what he was doing, and he was not cutting and digging. He was scraping it off the surface and plucking out bits of granulated tissue. So that's wrong. That's a mischaracterization. So what does he have, the plaintiff's expert? He has this tutorial. Here's how the progression of a wound healing is. Day this, you can expect this, and by day that, there'll be some granulate. By day this, it'll be in this condition. And by day, whatever it was for Mr. Lee, says the expert in lay terms, it should have been strong enough, you wouldn't expect it to come apart by itself. But what the expert doesn't do is apply this tutorial, which could have come from a textbook, to the situation. Our expert says, it was a factor that he was 81 years old, Mr. Lee. Plaintiff doesn't mention that. It was a factor that he had poor nutrition. Dr. Chia said that. From his personal knowledge, he was following his patient. And the plaintiff's expert says, his nutrition was adequate. Well, no, it wasn't. That's nowhere in the record. That's contrary to what Dr. Chia said. Our experts say this poor man's tissue was in a terrible state. That sigmoid colon that had ruptured, by the way, spontaneously, so things happen, spewed out fecal material, pus, bacteria, all kinds of stuff, all kinds of infection, weakened his 81-year-old tissue even more, and so weakened the tissue. What does plaintiff say about all that? Plaintiff's attorney, expert, nothing. He doesn't acknowledge that. He doesn't apply this, healing should be this way, to the actual facts of this man and his abdomen. So, and about the cough. He doesn't believe there was a cough. Well, there's evidence, the record of a cough, even from the plaintiff's son.
Counsel, you should wrap up now.
Yes, I just have to make this point. So what does the plaintiff's expert say? He says, Dr. Chia agrees with me that they must have cut the fascia or the suture. That's absolutely false. He's relying on a hearsay statement. What doctor relies on a hearsay statement from the son, which is in itself not clear? Maybe it was this, maybe it was the suture. Instead of looking at what Dr. Chia said under oath and what Dr. Chia wrote in his operative report, he said this weakened tissue was so weak it pulled apart from the suture. That's what Dr. Chia said. That's what makes sense. That's what all this evidence about his condition points to. This expert has nothing other than his subjective opinion. The fact that a plaintiff puts in an expert affidavit, that doesn't make a battle of the experts.
We'll consider that, counsel.
Okay. Our expert is supported. His
Counsel,
is not.
your time is up.
Thank you.
Good morning, Your Honors. May it please the Court, Bradley Stam for the plaintiff appellant, or excuse me, plaintiff respondent. I'm just going to be very brief, and I'll address any questions Your Honors may have. 2 quick points. What I believe is going to be a critical part of this trial, hopefully, someday, is the issue of this extensive necrotic tissue. And the reason I say that is because the defense wants to say that Dr. Chia has testified that the day before, as Justice Kerman correctly noted, the day before there was no extensive tissue such that Santil should be continued, chemical debridement. And then suddenly, the very next morning, the new team of residents come on board, and suddenly there must be enough extensive necrotic tissue such that a mechanical debridement needed to occur. And I disagree with the defense attorney when they say that Dr. Chia has essentially said, oh, they can make that decision. That's inaccurate. Dr. Chia said, we do mechanical debridement when there is extensive necrotic tissue. That's going to become a question of fact for a jury. The day before, Dr. Chia says, no extensive tissue at all. So we're going to keep going. It looked great. It's healing up well. In fact, he was getting ready to put him, but for the weekend, he would have been in a rehab facility already. And Dr. Chia talked about that. And then the jury is going to have to determine the very next day, suddenly these new residents see enough extensive necrotic tissue to do a mechanical debridement. That, I think, is going to be...
That was the first time these residents, this is the white team, right? This is the first time that the white team actually saw the patient. Is that correct?
That's correct, Your Honor. Early morning the next day, all of a sudden, they decided to completely change the plan. And my last point is that plaintiff's expert, page 606, 607 of the record,
directly takes on this very issue that they say he does not. By saying they deviate from the standard, by not only taking it upon themselves to abrogate the plan, but then initiate this sharp debridement in place of the previously effective and ordered chemical debridement. This case is very straightforward, Your Honors. And it's going to come down to whether a jury believes that within a matter of several hours, this gentleman went from, let's use Santo, we've been using it for 17 days. This is post-op day 17, not post-op day 2 or 3, 17. And then suddenly, because the residents are around, we're going to suddenly change this. Doesn't make any sense. And the last thing I will say is Dr. Carter, he's the one that wrote the order at Dr. Chia's request. And suddenly they're saying Dr. Carter should be let out. I'm never abandoning my claim with Dr. Carter. He's the one that actually wrote that note to you, Santo. Thank you, Your Honor.
Thank you, Counsel. 786, Sojda versus E&R General Construction.
Morning, Your Honors.
Good morning, counsel. Let's just wait for your opposing counsel to show up on video.
Yes, thank you.
Mr. Walls, can you hear us?
I can.
We can hear you clearly. We can hear you clearly, counsel.
Morning,
Thank
Mr.
you.
Wallace.
Morning.
Counsel, please proceed.
Thank you, Your Honors. May it please the Court. Ann Wheeler for the plaintiff appellant, William Soida. The question on this appeal is whether the defendant owed a duty to the plaintiff under Labor Law 241-6 and 200. A contractor owes a duty where it has authority over safety in the area where the plaintiff was injured.
Counsel, let me interrupt your argument with kind of a, if I can, a question that I'm concerned with. We have, I think, pretty clearly in the record, testimony that what's transpiring when the accident happens is is it a pre-test, I think is the phrase that's being used, where the plaintiff and a co-worker are testing whether or not a valve will properly open or close.
Correct.
Is that right?
They call it a test shutdown.
Test, yeah, well, that's kind of where I'm getting to, because my concern is that if that activity is being done in anticipation of a subsequent actual shutdown for purposes of the construction project, is it removed from the project? In other words, is this something that the Erie County Water Authority and its employees are doing so that they can be ready for when they have to shut it down, and they know they'll be able to shut it down? I wonder if the pretest falls outside of the actual construction project, where if they were there to shut the valve so that the construction can take place some half a mile up the road, that might be part of the construction project. Do you follow my question?
I do, Your Honor, yes.
All right.
I think there's several pieces of evidence in this record that makes a sufficient connection between the test water shutdown and the work, and the test water shutdown and E&R's contractual authority to provide safety. So from the testimonial standpoint, we have the testimony of the plaintiff who said we try to coordinate when we do the test water shutdown when E&R digs the test water, the test pits. So there are test pits that are dug in the excavation area, so the contractor can ensure that it's not going to hit pipes when it does the full test. The plaintiff testified that they try to coordinate those two activities. The evidence in this record, there's a daily engineering log from the night of the incident that shows E&R checked in at the job site with the contractor's engineer to let the engineer know, we're here, we're doing the test shutdown. That's in the construction logs, contemporaneous test shutdown, test water pit. There is testimony in this record from the ENR witnesses that that was coincidental in this case, that they didn't know that ENR was going to be there. But I think that there's certainly a question of fact in as much as the project's own engineer knew.
Mr. Damstedter from the Erie County Water Authority was actually at the site of the construction work, the half-a-mile site away. I think we're talking about the difference between Transit and Sheridan and Transit and Maple, is that right?
Correct, Your Honor, yes.
Yeah. So a representative from the Water Authority is at the area of the site.
Correct.
Right? Is there some indication in the record that Damstedter told the people at the site that they're going to be pre-testing the valve, or whatever phrase you want to use, at Transit and Maple, and so that they were all on the same page as to what was going on? I didn't see that.
There's no specific testimony that we're going to be shutting down the valves, but the ECWA valve crew is checked in. So I think that there's certainly a strong inference that if the valve crew is there, they're going to be shutting down valves. So it's not only Mr. Damstedter, it's the valve crew, and that's logged on the log. In addition to the testimonial evidence of what was factually happening that night, we have in the general requirements of the contract, which are within the project specifications, the requirement that ENR notify the ECWA 5 days or more in advance of when the water valves are going to be excavated, of their readiness to do that, for the specific purpose of the ECWA being able to come to the site and ensure that a shutdown can be complete. That is other verbiage for a test shutdown. So the contract documents specifically acknowledge that a test shutdown is going to be done as part of the work. And then if you look at that provision in the context of the type of protections that the ENR is supposed to provide, the most important provision in all the contract documents, and there are a few that are important, but the one in the general conditions that pertains to safety is section 6.13. And 6.13 says that ENR is responsible for providing protections, all types of protections, all safety programs, precautions, for all those at the site, the physical site where the excavation is being done, or all other persons who may be affected by the work. I think if you read that provision in connection with a specific acknowledgement in the contract documents that a test shutdown is going to occur, in addition to the other provisions of the contract that acknowledge that ECWA is the only person that can control the water, that there's work by others, including the ECWA, that's going to be done, and that ENR is responsible for coordinating all of that work, for ensuring safe access and safe completion of all of that work. I think when you look at all those things.
So if we look at those, your position is if we look at those contractual provisions, they all, when read in total, draw in this pre-work that's done on the valve to test it.
Correct.
Right?
Correct.
Is there anything in the record that indicates that the ENR had noticed that work that they were doing on the date of the accident was being done?
Had notice of the test shutdown.
Yeah, had noticed and were aware that test shutdown was taking place at Transit and Maple.
The ENR, I apologize, the ENR foreman testified that he did not know that. So it's his testimony that he was unaware that was taking place. But I think that is contrary to the engineer's log, which says the ECWA valve crew was there. There's no other reason for the valve crew to be there other than for shutting down the valves.
All right,
as part of the test shutdown.
Continue, Counsel. Yeah.
Okay, thank you, Your Honor. So the question is the duty, really, and the duty flows from the contract. The owner in this circumstance, because ENR is the contractor selected to do all this work, it delegated a broad amount of authority over the work. That includes, like I said, the coordination between ENR's own employees and any other contractor that might need to perform services in connection with the project. It expressly acknowledges that ECWA is somebody that's going to have to provide services by virtue of shutting down the water valves. Again, there's that notice requirement in the contract that sets forth that ECWA is going to be on site to perform specifically the test shutdown itself. And then the contract gives the broad duty and authority for ENR to ensure the safety of all people that'll be affected by the work. I think that's sufficient under the case law. I think that the contracts, while not always dispositive, when they're as clear as they are in this case, in contemplating the various steps that are required before the work can be completed, that creates a clear minimum question of fact that ENR is a type of contractor that owed a duty to the plaintiff under this circumstance under Labor Law 241-6.
We'll take a look at that, counsel.
Thank you. And then briefly with respect to Labor Law 200, it's a similar analysis. If ENR had the authority over the general area where the plaintiff was injured and there was a question as to whether they're on notice, then the Labor Law 200 cause of action should survive. I'll note that in the respondent's brief, they raised the issues of whether the code rules were applicable to this set of facts. I don't think that issue is properly before the court. The lower court did not decide that question. It specifically opined that because the contractor status was found in the defendant's favor, that they were not going to address the applicability of the regs. The defendant did not file a notice of appeal on that issue, so I don't think that the question of applicability is properly before the court now. If the court is to consider the merits, my brief fully sets forth that the plaintiff was injured in a type of work area that would be contemplated by Code Rule 17D, that there is certainly a question of fact as to whether the illumination reg applies. The plaintiff testified that it was dark, that he couldn't see what he was doing. Had he been able to see better, he might have done something else in terms of where he positioned his feet. And then the hand tool reg as well, I think there's a question of fact as to whether the hand tool was in a broken condition.
And you concede the other section doesn't apply. There was a third section that you cited in your bill particular, which I believe that I think has been conceded.
Yes, there's three code rules: the illumination, the hand tool, and the slipping hazard reg are the ones that we think at least there's a minimum question of fact as to whether they apply.
All right, very good. Thank you, Counsel.
Thank you, Your Honor.
Mr. Wallace.
May it please the court, there's absolutely no dispute that this accident occurred when plaintiff, an Erie County Water Authority employee, was doing work for the Erie County Water Authority, utilizing a method and a procedure devised by the Erie County Water Authority, under the direction and control of the Erie County Water Authority, was injured when a tool and provided to him by the Water Authority broke while he was using it. Plaintiff's accident occurred in an area 2 to 3 city blocks away from where my client ENR was working. No ENR employees were ever present in the area where plaintiff's accident occurred, and ENR did not, nor was it required to provide any direction, instruction, tools, equipment, control, or supervision over the activity plaintiff was performing. The evidence is undisputed that the Water Authority was solely in charge of shutting down all of the valves on the project. ENR was not hired to turn off the water, nor could they. To Justice Whalen's point, the first question he asked, is the act of turning off the valve by the Water Authority removed from the project? That's exactly the point, Your Honors. If you look at Russin versus Picciano, Court of Appeals case, where you're looking to determine if a contractor who isn't an owner or general contractor may be held liable, that contractor has to be delegated the work and exercising the control and supervision over the activity that's being performed. Here, ENR was never delegated anything having to do with turning off the water. That's solely the Erie County Water Authority's job and responsibility. ENR had no notice as to when any of these people come out. ENR had no idea where any of the valves in the Erie County water system were located. The idea that Appellant's counsel wants this court to accept is that by culling and weaving together various provisions of an enormous contract, frankly, that somehow places ENR having responsibility for everything that happened on the project, including all of the work performed by Erie County Water Authority. And I submit to you, for the reasons articulated in the brief, that is simply not the case.
Anything further, counsel?
No, Your Honors.
Thank you.
Thank you.
And we're on to the last case. Yeah, 878 submitted, I think. Call this
787?
787 is, I have it,
Oh, I didn't see.
I have it marked as submitted. So that leaves the last case. All right.
Okay, let's call the cases 7, 8, 9 through and including 791, I think are the numbers. And our presiding Justice Whalen is recused.
Ready? May it please the court, your honors. In 2014, Vince Crean was retired. In 2015, Kathy Arid was retired. 6 and 7 years later, they're unretired. For me, the forest through the trees is that's arbitrary. And backing into how it's arbitrary, and forgetting about all the other things that the lower court ignored, statutes of limitations, latches, all the other contractual claims that we made, it boils down to, is there a remedy in the plan? Because we're not an ERISA plan, you don't look at the ERISA statute. Is there a remedy in the plan to recoup what they now say are overpayments? And that question was answered by Mr. Stuhlmaker at page 565 of the record in a letter to the IRS where he says there's no provision to reduce benefits to recoup money. End of discussion. There's no provision in the plan to even provide that remedy. And that's why we sued on different grounds for declaratory judgment and all these other things. The language of the plan doesn't allow them to do what they did. They'll say, and they have said, well, the IRS compelled us, made us do this. But that's not what the record says. The IRS, in their back and forth, says, well, you've got options. Their guidance says, if this is not an ERISA plan, or if this is not a private plan, if this is a government plan, mind the state law. Mind the state law provisions for contracts. Mind the state law constitutional provision here that Mr. Stuhlmaker also made the argument on. Mr. Stuhlmaker made all my arguments for him until he didn't. And that's where there's a gap in what they say. There's a plethora of documents they've attached here, and it's, this is the new status of 3211 motions. You've got papers this high. But there is nothing after August to show why this changed. After August of 2020, I should say. And then they say they met with the IRS on September 20th, and in January, my clients get the letters. Mr. Stuhlmaker says this first came to his attention in 2018 when another woman who worked there and had retired came back to work for the company, not for the union. And so by that time, my clients had gone. They were done working for the union. Why? Because they retired. They couldn't run for the union anymore. When you retire, you can finish out your term, but you can't run for the union.
Mr. Walsh, is there any, and I'll ask the same question for the funds attorney too, but is there any dispute that your clients were qualified for the early retirement that they were afforded?
No, there's no dispute. It's the 57-87 rule under the plan, and they met both requirements. I think Ms. Zehrig, her pension was a little higher, but she worked longer. But both of them met the requirements for early retirement.
And the fund granted them the early retirement pursuant to the plan?
Correct. And there were two company trustees who voted both times for both to do that.
When you say two company trustees, the fund is governed by union trustees and company trustees, Metro trustees, right?
Right.
It's kind of a standard union fund
Correct.
program. And there were 3 signatures, as I understand it, to the one document for Mr. Crean. And I think the one is Ms. Novo, and probably, I read the one signature. Right. So it's Mr. Crean, Ms. Novo, I think that's the name, and I couldn't read the 3rd signature on that page. Who was that?
I think that was Giza.
Who is it?
Ron Giza.
And is that that's a Now,
Company
union
trustee.
trustee, that's a.
Company.
And was Novo, or whatever her name is, also a company trustee?
Yeah, she was the director of HR for NFTA.
And then there was a different signature for Ms. Ehrig.
That's right. I think that was Patrick Dalton.
And
also.
is he company union? Not that it matters necessarily, but I'm curious.
I believe he's company.
Okay. So they make a point in the fund's brief that, the way I read it, I'm not sure they mean it this way, that there's something nefarious by the fact that your client and your client's signatures are on that. But I'm not reading the record here or briefs as saying that there was anything that was inconsistent with the plan, or that the early retirement was not authorized by the plan, or that your clients were not qualified for early retirement pursuant to the terms of the plan. Am I close?
You're correct, Your Honor.
So they would say they did everything right back in 2014 and 15, and now we're doing everything right, even though it's directly to the contrary.
Right. So, was it arbitrary and capricious when they did it in 2014 and 2015, now that they're saying that they're unretired? Let's say it was. Is that negligence because they shouldn't have allowed it back then? And is there a remedy there? And we sued for negligence. And they have insurance.
This case is in a bit of an odd posture, at least from my perspective.
Yeah.
That is, theoretically, this could have been phrased in a mistaken payment cause of action.
Right.
That is, the trust could have come after your clients for a mistaken payment. Say, hey, we made a mistake back in 14 or 15. But I don't even see that they argue that they made a mistake back then.
I haven't seen it.
And they say that the action they took was pursuant to the plan and the IRC, but I don't see where they're saying anything where they acted in 19 contrary to what they did in 14 under the plan. One or the other is correct.
Correct.
And they interpreted the plan apparently two different ways, and only one can be correct, right?
Well, that's what I believe. I think they'll cite some case law under the ERISA statute that's saying, well, even though the courts will say, well, maybe we don't agree with what they did, but it's within the bounds of reason, it's not arbitrary and capricious. I think that's the counter argument.
And let me take you to, I didn't mean to cut off your argument.
No, that's fine.
Either, but I'm really struggling with whatever duty you say, and it's interesting, in your complaint, you say that the lawyers had a duty to the fund, the trustees. You don't say they had a duty to your clients. I think the whole idea of a duty here, Mr. Walsh, by the two attorneys was quite the stretch. What's your response to that comment?
Well, I would expect you to say that, Judge. And I don't relish suing lawyers, but in this case, if I didn't, I'd be hit with the fund saying, well, it's not our fault. Everything was fine until the lawyers screwed it up. The lawyers were the ones who went to the IRS with the voluntary thing, and we don't know exactly how that happened. Although,
where's the duty, Mr. Walsh? Where's the duty to your
that's the
clients
fiduciary rule. So there's a trust and there are beneficiaries. Who's the real client? Do the lawyers and the fiduciaries have no duty to the beneficiaries? If they did nothing and the trustees did this all on their own, certainly I wouldn't be suing the lawyers. But the trustees didn't do that. What happened was Mr. Smith, who had the Metzger case, said, we can apply that to this unit. And guess what? I can get that union's business away from Mr. Stoolmaker. Mr. Stoolmaker, who, to his credit, made all the right arguments all the way until he didn't, as I said, until the end. And how did that happen? We don't know what happened in the September of 2010. That's why it's unusual. That's why we're saying there's a duty here. Because they decided to act. It's like the cases where you may not have a duty, but then you act in a certain way that creates a problem. Now you've assumed the duty. That's our argument on that. The only other point I want to make, Your Honors, is there's a mistake. It's right in the determination. It's at page, no, it's not at 126. It's right in the determination. They say that contributions were continued to be made by the company after they initially retired, as if they were still on leave. It's absolutely not true. It's not true. It's in their determination. We appealed it. In their appeal, we said, well, we noted that you correctly said that, but that didn't really matter to us. That didn't have anything to do with their decision. But that's after they had talked to the IRS. And so are they telling us that what they tell us is different than what they tell the IRS? Of course not. They had a mistaken presumption that the company was still funding as if they were still on leave. They weren't. They lost their benefits then were paid by the company. That's what happens when you retire. The company pays for the benefits, not the union, and that happened. They stopped with all their, other ancillary benefits. Those all stopped. And, as I said, they couldn't run for the union, so they were retired. To say they're not 7 years later is arbitrary. Thank you.
Morning. May it please the court, Brian LeClaire on behalf of the pension fund and the trustees. So just very briefly, by way of context and background, obviously we know this matter arises from the conduct of the two plaintiffs, the participants, who, as was noted at the time,
This arises from their conduct, Mr. Leclerc?
no, it does not. I think it's certainly a relevant fact, certainly to the extent plaintiffs have framed the case. I mean, if you read the complaint, you wouldn't know that fact as an initial matter in terms of their status as trustees at the time. And then to the extent there's allegations and assertions and insinuations that they're victimless, so to speak. We just think that that's
not how I read it.
Inaccurate, based on the fact that they were trustees at the time, right? That this notion of detrimental reliance on the conduct of the trustees told us A, B, and C. Well, we were trustees, and frankly, as trustees, they had an obligation to understand these processes. Now, they're not attorneys, they're not...
Mr. Leclerc, this gets down to my question I asked Mr.
Sure.
Walsh. I see nothing in this record, and correct me where I'm wrong, or in the briefs, where the fund has argued that what they did, granting early retirement to these plaintiffs, was in any way contrary to the plan. I do not see that in the record. Am I wrong?
Respectfully, yes, Your Honor. The plan is very clear and on its face that an individual participant must retire in order to be eligible for benefits. This plan, like many others, are not permitted by their own terms and by law, frankly, to provide in-service distributions. A payment of pension benefits to somebody that's still
working. Counsel, the crux is they started working for the union.
They had been working for the union continuously. Yeah. So the two plaintiffs had been longtime employees of Metro.
And then they retired, and use the vernacular, they were Metro employees as president and I think secretary of the union, but they were still Metro employees.
That's correct, on a leave of absence. Yeah. And the terms of the plan in this case provide that union employees are employees, capital E, under the plan. And this is perhaps, I believe we made it clear in the brief, I hope we did, but the union is also a contributing employer itself to the plan. So it is a direct matter an employer of the plan. So these individuals, regardless of what may or may not have happened in terms of announcing our quote-unquote retirement and the like, nothing changed in terms of their employment at the union before their applications for benefits at the time of the application, and then for a couple of years. I think it was closer to 3 years for Mr. Crean and less than that for Ms. Ehrig. It continued that same employment. At the time, the benefits were granted, and yes, Your Honor, that was erroneous. That was improper. Those benefits should not have been paid. And when this came to light, as Mr. Walsh points out, in connection with actually a couple of other individuals who were have sort of raised the same issue, and the trustees took a hard look at it, yes, with the assistance of counsel, which we think provided great advice in this situation. And the concern here was, wait a minute, this plan, which not only defines this retirement obligation, but also expressly provides that it must be interpreted in accordance with Section 401A of the Code, the Internal Revenue Code, which is obviously critical to the very existence of the fund. This concern arose, a legitimate concern.
Mr. Leclerc, one of the questions for me anyways is, I've read this, what do you call it, VCP.
Yep.
And I didn't see, and I think it's the plaintiff's argument that it is not in there, any reference to the fact that the fund had in fact granted these plaintiffs early retirement as sort of a special issue. I didn't see any discussion in the VCP of the fact that the fund afforded these plaintiffs the particularized benefits of the early retirement. So I saw no mention of early retirement in this document. Is that correct?
That there's no mention of the special early retirement benefit?
Correct, as opposed to just a general retirement. And they also point out there that neither plaintiff was above the age of 62. I don't see that that's relevant to having granted them an early retirement. But my question is fundamentally, is there anything in here that discusses or discloses to the IRS about the early retirement that they were afforded?
I believe there is. I don't have it open to the page in front of me, but I'm not sure it's relevant. The special early retirement provision in the plan still requires the individual to retire. As Mr. Walsh pointed out, yeah, these individuals had the appropriate time in and the appropriate age met. That's not in dispute. The question was, did a retirement occur? And I think that was really the issue that prompted the sort of reporting of this issue to the IRS. And as you can see in the correspondence that we've submitted between Fund Counsel and the IRS, the fund didn't want to recoup these benefits. The fund is trying to satisfy its obligation to comply with the code. It's got hundreds, close to 1,000, I believe, participants that it has a fiduciary obligation to take care of, to protect. And it reports this issue and essentially begs the IRS not to require recoupment.
So sticking with the idea, and I'm sorry to keep interrupting this, Claire.
No, that's fine.
It's an odd case for me anyways. But theoretically, the folks who authorized this early retirement that you say was against the terms of the plan and against the IRC, those trustees theoretically could be pursued legally for that, correct?
Vince Crean suing Vince Crean? I mean,
Well, no,
not to be
more than
flipped,
that.
not to be flipped. Yeah, no, not to be flipped, Your Honor.
Trustees might be indemnified by the fund and might not be.
I don't think the trustees' actions in granting, and again, trustees, capital T at the time, you had the group of trustees at that time that granted these applications were engaged in any malicious conduct, okay? But that doesn't change the fact that this was not done properly by virtue of the IRS requirement of a retirement and the potential for some real fallout for the plan. They didn't want to do this. They did it out of an abundance of caution and because it was the reasonable, really the only reasonable thing to do to report through the VCP program. And frankly, they thought the recoupment wouldn't be required. And as you can see, Mr. Selmaker, apologies, attorney for the fund, argued zealously for that. Ultimately, the IRS apparently had to have its way, require the recoupment. What were they to do? And I think this just sort of underscores we're not revisiting this. I don't think this Supreme Court revisited this sort of de novo. I think he properly viewed it through the arbitrary and capricious standard. So when you look at it through that lens, we don't see the merit at all. And
now, one of the things that Mr. Walsh touched on, I'll give you a chance to touch on it too, is in a way looking at the Supreme Court's decision about the finding that, well, it's clear that the plaintiffs did not actually retire. When I read language like that in a 3211A1 or A7, particularly A7 context, that strikes me as kind of hard to do in that context, and that really sounds more like summary judgment. Do you think, and I think this is what Mr. Walsh has suggested today and then in the brief, that maybe Supreme Court pulled the trigger too quickly on this and should have awaited summary judgment?
No.
So you get, is it in the right context here?
Your Honor, I think this case proceeded properly. I think this is not your typical 3211 case based on the fact that there was essentially an administrative record of below at the administrative level in terms of the pension benefit determination, the appeal that the plaintiffs made to the trustees determination denying that appeal, the plan document, et cetera. Almost every single one of the items in the record were cited or referenced in some fashion in the complaint. Papers were put in, I think, properly in connection with the motions, and even opposition papers and reply papers from the plaintiffs were attaching documents and providing affidavits. So I think what we ended up with was a relatively complete record, really administrative record of the pension benefit determination, which makes this something different than maybe your classic 3211 motion. And then you combine that with the arbitrary and capricious standard. I think the Supreme Court acted completely appropriately in dismissing the case. Everything was there in front of it, and it's not necessarily Supreme Court's job to interpret every last bit of the Internal Revenue Code. Its job is to say, were these trustees acting reasonably? And I think that's clear.
Anything further?
Nothing further. Thank you.
If it pleases the court, I'm Brian Suter on behalf of Mr. Stuhlmaker. I don't see that the fund has a defense that the lawyers made me do it. If that's the only reason why we're in this case, we shouldn't be in this case.
You'd be here as third-party defendants.
If that happens, that happens. We'll deal with it. But there's no attorney-client relationship here. There's no obligation here to these individual defendants. The obligation is to the fund. Preserve its tax-exempt status. Let the lawyers out of the case. Thank you.
Good morning, Your Honors. Michael Brady on behalf of Attorney Jules Smith. Judge, let me start with your comment that the case against the lawyers, and I'll deal directly with the case against Mr. Smith, is quite a stretch. It's beyond a stretch because it's contrary to the law of this court and the courts throughout the state. That you
Mr. Brady, in
can't.
fairness to Mr. Walsh, he's sort of darned if he do and darned if he doesn't, because Mr. Stuhlmacher is the one who submitted the VCP. And, you know, for all he knows, the trustees could be saying along the lines Mr. Suter just represented, like, geez, if they're going to say we're going to blame the lawyers, it's up to the fund to do so. So it's a bit of a tricky situation where the lawyers are sort of driving the bus here, right?
No, Your Honor, under the plan, first of all, under the plan, the trustees and the trustees alone have the responsibility and the authority to interpret the plan and to determine eligibility for benefits. The fact that they may have sought legal advice is really beside the point, and it goes against a settled law that a party can sue someone else's attorney for the advice the attorney gave his opponent. That's what it comes down to. And to give you the sense of it, Judge, at page 38 of their brief, the plaintiffs say, whether granting the pensions as originally approved would cause the pension plan problems with the IRS is not and should not be the plaintiff's problem. So as to Mr. Smith, they're arguing Mr. Smith, gave advice to the trustees in the plan, but you owed us a duty as an attorney. Us, two of us, out of 1,000 beneficiaries, you owed us a duty. And so the idea would be, either as an attorney or a beneficiary, that Mr. Smith was to take a look at this situation, take a look at the fact that the IRS had a private letter ruling that was cited in the voluntary compliance submission by the trustees, and say, wait a minute, it might have an impact on these two individuals. I've got to take their side, and put the entire pension plan at risk with the IRS. That puts the law on its head. The entire case against Mr. Smith is that he acted as an attorney providing advice to the trustees and the plan. And earlier this year, Your Honor, and I think it's called the Shiloh case, this court said you can't sue somebody else's attorney. He's not your attorney. The plaintiffs don't claim an attorney-client relationship. They admit and say right in the complaint, Mr. Smith was providing advice to the pension plan. So there was no basis to bring the lawsuit to begin with, but Judge Koliakovo was entirely correct in dismissing it. Thank you, Judge.